Thanks everyone for joining us today. Just our quick kind of standard disclaimer. This presentation is for educational purposes only. It's not legal advice and doesn't create an attorney-client relationship. We'll have some information at the end on contacting us if you have some specific questions on the materials presented here today. We'll go through this somewhat quickly as we normally do so that you can also get on with your day and get on to other items that you need to attend to. So to start with today, we're going to talk about some state law changes for 2025 and beyond. We'll then get into some broader topics to watch at the federal level. If you have specific questions, again, if you're a client, send us a ticket. That's the best way for us to get on board and help you as quickly as we can. Otherwise, if you're interested in becoming a client, the information is available as well. Overall, it's good to see what's going on in all of these states. We're basically focusing on law changes for 2025. This is kind of a webinar we've been doing over the past several years at the request of our clients because you listening find it very helpful to know what's going on. This is especially true if you're a multi-state employer. There may be items today that you were not aware of and that you want to stay on top of. Also watch our weekly email that Dan had mentioned because we're going to have some upcoming webinars that are going to address issues that are going on at the federal level. We're going to, towards the end of this webinar, talk broadly about some federal topics. We're starting with state law, obviously, but there's a lot of changes currently happening, and we want to provide information as we go along with our webinar series to help employers address changes at the federal and the state level. So let's start with Alaska. There's a pretty big new law that's occurred there, and that's a paid sick leave law. It will be effective later this year, July 1st, and it will cover employers of 15 or more employees having to provide 56 hours of leave annually. If you're under 15 employees, you'll have to allow accrual of up to 40 hours. The accrual rate will be 1 hour for every 30 hours worked. That's pretty standard as things go with paid sick leave laws across the country. My thought is on this is to start preparing for this law effective date of July 1. We're going to move on now to California. We'll, just as an FYI, be going through the states alphabetically. With some of these states, you'll see they have more than one slide because of law changes for 2025. California is one of those states. If you are operating in a state that has law changes for more than one slide, you probably already know it is a challenge for employers, but we are, again, here to help you, provide information, provide advice. But California definitely has more than one slide, and you'll see some other states that are very employee friendly that do as well. So let's start off with some amendments to the Fair Housing and Employment Act, the FEHA. There are going to be, or there are some changes that have come into effect, I should say, earlier this month that are significant for the FEHA. So you can't discriminate if you're an employer based on any combination of protected classes. So this just adds another arrow in the quiver of an employee or an employee's attorney to say, not only was I discriminated against based on these single protected classes, I was discriminated against based on a combination of the classes. Really, it's just sort of a piling on, but that's just something to be aware of. Additionally, within the FEHA, the definition of race has been amended to include traits associated with race, not just traits historically associated with race. And basically what that means is hairstyle or natural hairstyle discrimination is explicitly prohibited. You may have heard of some of these laws across the company. They're called a Crown Law or the Crown Act. This new update to the FEHA in California codifies the Crown issue. In addition, municipalities also have the ability to now enforce state and local anti-discrimination laws. Generally, before it would be a state agency. Well, now a city or town or an agency within a city, town, or other municipality can now try to enforce a state law against an employer. They don't have to go to the state. It can be done at the local level as well. There are a couple other big laws in California that have some amendments we want to talk about. The first is the amendment to the paid sick leave laws. Employers must now provide sick leave to agricultural employees during a smoke, heat, or flooding condition created by a local or state emergency. This is relevant with the recent wildfires in Southern California, but just keep in mind that if you have any agricultural employees, this new provision has been added into the paid sick leave law. The paid family leave law, that's another huge law in California. Employees can no longer be required to take up to 2 weeks of their PTO or vacation prior to using paid family leave. Before, there was more flexibility for an employer. Now that flexibility is gone. You cannot require an employee to take their paid leave, company provided paid leave first before taking paid family leave. If you've got a paid family leave policy, you may want to check it to see if it needs an update. And these changes, as noted, are effective as of January 21 of, or January 1st of this year. There's a couple other laws that are new, also both effective on January 1st of this month, that are interesting. The Freelance Worker Protection Act. This is a new law for employers hiring freelance workers. You must now have a written contract that contains the requirements provided in the new law. So people are asking, well, what about independent contractor rules? Those sorts of things. Well, the freelance worker is a unique structure out in California. To be a freelance worker, to be covered by this new law, it can't be more than a single person. So a single person could have a business entity. They could be an LLC, they could be a corporation, but to be a freelance worker, there cannot be more than one person inside that business entity. So freelance worker is a single person. They're also not an independent, or they are an independent contractor, I should say, under California law. So the freelance worker has to be truly a freelance worker. They have to be considered an independent contractor, of course, not an employee. They must also provide professional services, and they must maintain independent control over their work. So think about this as kind of an enhanced independent contractor or freelance worker, but that's just something to be aware of. If you have freelance workers, you have to have a contract with them. You have to have the names and addresses of the parties. You have to have all the payment details, and you have to have itemization of services. So that's just something not everybody uses or would use a freelance worker, but that's something to consider. The California Workplace Violence Prevention Law, employers can now seek a temporary restraining order against an individual who has harassed employees. So it doesn't come down to your employee. Say you've unfortunately got an employee in a domestic abuse situation, the alleged abuser keeps showing up at your workplace, disrupting things. Now it just isn't on the employee themselves to seek a restraining order. Now an employer can take some proactive steps to help protect their affected employee, their other employees from this person, and the workplace overall. So this may be seen as a more positive development for employers, because now if you're an employer in California, you have the ability to seek a restraining order against somebody if needed. Also in California, there's been some amendments to the workers' compensation laws. If you're providing workers' compensation notices, you must include first, that the employee has the right to consult an attorney, and second, that the attorney's fees will be paid in most instances. That's a new requirement. There's also a new law in California that prohibits job applicants from being required to possess a driver's license unless driving is part of the job, or if alternate transportation would not be comparable for the employer. So in other words, you can't condition somebody having a driver's license on them receiving a job unless driving is basically part of the job. So this is effective January 1st, 2025. Same with the workers' compensation amendment. So a lot of things have happened in California as of the first of the year. There's also a local law update in California. We've been just discussing state law updates. There's a local law update. Los Angeles County has a predictable schedule ordinance. It affects Los Angeles County retail employers with 300 or more employees. The total number of employees can be located in any state or states or globally. So it's 300 workers anywhere in the world. if you have 300 or more of them in your retail business in Los Angeles County. If you're a covered employer under this law, you must give employees predictable schedules. What does that mean? You have to give them schedules first 14 days in advance. Next, rest periods of at least 10 hours between shifts must be provided. There has to be compensation for last minute schedule changes, and there's a longer list of other onerous requirements. So again, this affects retail employers, again, 300 or more employees in Los Angeles County. This is effective July 1 of 2025. So if you think you may be covered, you better start preparing to be ready for this predictive scheduling law. The state of Colorado more recently has become kind of a more employee-friendly state. Luckily, we only have one slide for Colorado, but it's a big one. So there are amendments coming up to the Colorado Privacy Act. The effective date of this law change is going to be July 1st of 2025. And this is going to cover employers who collect biometric identifiers of employees. So think about if you're using a biometric fingerprint scan for a time clock, for example. There's going to be new rules that are going to be coming into effect in Colorado as of July 1st of this year. So first off, you're going to need a written policy regarding your collection of biometric information of employees. You're going to need to provide employees notice. The employees are going to have to consent to the use of their biometric data, and you're going to need some privacy protocols in place. This is a little ways off, obviously, 5 months or so down the road, but it's coming up. So if you're operating in Colorado, this is something that you definitely want to be aware of. The state of Connecticut has also passed some amendments to their paid sick leave laws. As you go through this presentation today, you'll see that there's a lot of changes to paid sick leave laws. This is one of the states that has some changes. So the amendments in Connecticut are going to cover employers with 25 or more employees. It's going to expand the reasons employees can take the leave, who's covered, how the leave allocation is calculated, things along those lines. And really what this means is that more family members are going to be covered so that an employee can take time off under the Connecticut state paid sick leave law to assist a family member if they need something. This law is already in effect as of January 1st of this month. Delaware has a law called the Healthy Families Act. It's basically a state paid family and medical leave law. It allows up to 12 weeks of paid leave to bond with a new child, to care for a family member's or an employee's own serious health condition, or if there's a qualifying military exigency that an employee may need to attend to. So if an employer is using the state's Healthy Families Act, if you have 10 or more employees, you've got to start payroll deductions if the employees themselves are contributing to the cost of the leave. The effective date was the 1st of this month. So something to think about if you're in Delaware, you're using a state plan, and you've got 10 or more employees, there's some changes that you need to attend to as of this month. Illinois is another one of our states with more than one slide today. Anybody who's listening who operates in Illinois knows that it is an extremely employee-friendly state, and that it seems more and more regulations are applied to employers every year. And so this is going to give, the next few slides will give some updates on what's going on there. The first big change is to the Equal Pay Act. Job postings for employers with 15 or more employees must now include a pay scale and benefits. So that is something to think about with your job postings. The Human Rights Act has also been expanded in Illinois. There is a new swath of protected classes relating to reproductive health decisions. Both of these changes are effective as of the 1st of this month. And part of these are a reaction to what some states think are going to be upcoming federal activities regarding employee issues. So some states are trying to be proactive with passing laws to favor their residents, their employees. January 1st again for both of these changes in Illinois. Another new law in Illinois is the Worker Freedom of Speech Act. Basically, it means that employers can't threaten or take an adverse employment action against an employees who decline to attend an employer-sponsored meetings. So what this basically means is that an employer can have employee meetings, but an employer can't basically compel the employees to attend. You can say a meeting is mandatory, you can ask that everybody show up, but to force somebody or discipline somebody for not attending would likely run afoul of this law. It basically, it's basically in place to limit an employer's ability to speak out against unionization. That's the basic purpose of this law, but that's just something to keep in mind, that you can't compel somebody to attend a mandatory meeting under this new law. The Personnel Records Review Act has also been amended. It expands the categories of documents that an employee may request. So now it includes things like contracts or agreements that bind the employee. It would include your employee handbook, and it would include all of your written employer policies. Just something to keep in mind if you are in Illinois and you get a request for personnel record information from an employee or former employee. These changes are effective the 1st of this month. The Wage Payment and Collection Act has been amended in Illinois. Employers must now keep copies of pay stubs for 3 years, and they need to produce those pay stub copies to an employee or former employee upon request. The Whistleblower Act has also been updated, and the employees are protected from disclosing or threatening to disclose information on activity, policy, or practices of the employee in good faith, or that the employee believes in good faith violates the law. So in other words, employees under federal law and under most state laws did already have some whistleblower protections, but this law basically expands employee protections in Illinois. This law was effective on the 1st of this month, or both of these changes, I should say, were effective on the 1st of this month. So that is something to keep in mind. And we're not done with Illinois. Freedom to Work Act is in place. It prohibits non-compete or non-solicit agreements for construction workers. I know that many of our clients work in the construction field as contractors, either general or subcontractors. This is something to keep in mind when you're hiring people. Human Rights Act amendments have occurred in Illinois. So family responsibilities is now a protected class that basically is similar to other states that protect something called familial status. So you can't be treated differently if you have kids versus somebody who doesn't have kids, things along those lines. Or if you're married or not married, that's what family responsibilities can relate to with some of these changes. And both of these things went into effect the 1st of this month. A big issue that's occurred in Illinois that we've had a lot of questions on from employers involves a new law in Illinois that addresses the federal E-Verify system. And E-Verify, just as a reminder, is a voluntary federal program that employers can use to check out the identity and the ability of someone to work in the U.S. That's something that can be used to supplement the I-9 process. Many states, or I should say some states, require use of E-Verify. Other states like Illinois are strongly against the use of E-Verify. So what has happened with this new law that was effective on the 1st of this month regarding E-Verify is that if you're an Illinois employer and you're using E-Verify for your Illinois employees, you've got a whole new set of requirements and procedures that you need to follow if a notice of discrepancy comes up on a person. Basically, if you receive a notice of discrepancy through E-Verify, the employer must provide the applicant or employee with notice of the discrepancy and information on how to contest the discrepancy with the government, and the employer has to do that within 5 business days of receiving the discrepancy notice. So if you're an employer in Illinois and you're using E-Verify, you basically have to help the employee who's flagged by E-Verify to get through the E-Verify process. This is a sort of a unique law. We haven't really seen this before, but again, expect to see legislation like this in states that are maybe opposed to more rigorous controls on things like immigration and hiring. You may see more of this, but if you're using E-Verify in Illinois, there are a lot of steps, and it's something that if you've got a question on, you want to reach out to us. There's a child labor law of 2024. There's new requirements if you're hiring minors and you work in Illinois. For example, you've got to get an employment certificate. You've got to comply with certain hours worked limitations. There must be an adult that's 21 years of age or older supervising minor employees at all times, and you've got to provide meal breaks. Some states already have this type of law in place where they're real protective of younger workers, but now Illinois has basically just codified this going forward. Moving on, so the state of Kentucky, or I should say the Commonwealth of Kentucky, has a new medical marijuana law. Employees are now allowed to possess medical marijuana with appropriate medical authorization. However, employers do not have to accommodate medical marijuana use at work and can still enforce drug testing and drug-free workplace policies. So what this basically means is that even though the Commonwealth of Kentucky now has a medical marijuana program, that doesn't mean that your employees who are using medical marijuana get any employment protections. In some states like California or Minnesota that are very employee friendly, there are written into the medical marijuana laws employee protections. Kentucky, they're going to say, yeah, we have this medical marijuana law. However, our employers can still take adverse action with an employee. There's no employment protections for an employee using medical marijuana. That's just something to keep in mind if you've got staff in Kentucky. The effective date of this law is going to be July 1st of this year. The state of Maine has a paid family and medical leave fund. Basically, employer and employee payroll tax contributions will become effective on July 1st of this year. It will be a 1% contribution split evenly between the employer and the employee. This is 5 months out, basically. So if you're operating in Maine, you want to talk to your payroll provider to make sure all of the provisions are in place for those contributions. Maryland has a paid family and medical leave insurance law, otherwise known as FAMLY. Similar to what we just discussed with Maine, contributions through payroll taxes are set to begin on July 1st of this year. So talk to your payroll provider, start preparing now, because this will be here soon. If you're operating in Maryland, you want to be prepared. Massachusetts has a couple of laws in place that are affecting employee pay, and we want to just touch on those. So there's now a new salary range transparency rule. This is basically into two parts here. So part one, we're going to discuss first. Employers with at least 100 employees and subject to either the EEO1, EEO3, EEO4, or EEO5 federal reporting requirements must file a wage data report with the state of or the Commonwealth of Massachusetts containing aggregated wage data by race, ethnicity, sex, and job category. This law goes into effect next month, February 21st. Really, if you're already doing any EEO reporting, you know that this is kind of burdensome at the federal level. It's going to be more burdensome at the state level. So this is something you want to start preparing for with that February 21st effective date. Part two of a change that's going to occur this year is employers of 25 or more employees in Massachusetts must provide the pay range and job postings, and that has to be provided to current employees who are promoted or transfers, and also to current employees upon request. Now that goes into effect later this year, October 29th. But again, keep this in mind. You know, if you keep a copy of this slide deck from today, keep this in mind if you're in Massachusetts, and note that these requirements are going to be coming up later this year in both cases. Minnesota, one of our employee-friendly states that we mentioned earlier, we've got more than one slide on Minnesota, but we'll get into it. Similar to what we just talked about with Massachusetts, there's a pay disclosure law. It's going to be effective, or it is effective as of the 1st of this month. So now employers with 30 or more employees must include a pay range or fixed pay rate in job postings. Also for independent contractors in construction, construction employers now have a 14-point test for determining worker status as either an employee or independent contractor. That's going to be in effect in about a month, so March 1st of this year. And so that 14-point test for whether a construction worker is an employee or an independent contractor in Minnesota is going to involve factors that are not unusual for independent contractor tests, but you've got to pay very close attention and look at each factor if you're looking at a construction person in Minnesota. So some of those factors include separate business for the person. They own or rent business equipment and real estate. You know, you're not providing that to them. They offer their services to the public. They have tax information on file for their business that they've created. They pay into their own unemployment. They have work comp insurance, things along those lines. Again, it's a 14-point test, and it's just basically meant to put up another hurdle for construction companies to work through their compliance process. If they're bringing somebody on board and they think they're an independent contractor, you really want to go through this new test to verify whether they're an independent contractor or in fact they should be classified as an employee. Minnesota also has a Debt Fairness Act. It's going to be effective on April 1st of this year. That means basically that there are new garnishment limits for employers in Minnesota. If you're the employer, your payroll department receives a garnishment notice for one of your employees. Some of the information is changing. There's a bunch of formulas involved. I won't go through it, but just keep in mind that as of April 1st, some of the information on how much you can garnish from people is changing. Another law that will be effective later this year in about 6 months, the Debt Fairness Act with the independent contractor rules. This new law means that employers or businesses who hire independent contractors can't take an adverse action against their independent contractor based on a garnishment. So if you have somebody that you've properly classified as an independent contractor, they're not your employee, however, you're paying them for work, you get a garnishment notice. You can't say, hey, because you're an independent contractor, you're out of here. I don't want to deal with this garnishment. You're compelled under this new law that you cannot take an adverse action if you've got an independent contractor working for you and you've got to process garnishment items for them. Also in Minnesota, there's kind of some big things happening with paid family and medical leave. The first thing is you have to have a state developed poster that must be either posted at your work site or provided to employees as of November 1st of this year. The state is going to develop that. You've got to make sure that you've got that in place so that you're properly following all of your notice requirements for the paid family and medical leave law. You can see here that there's these dates and what you must do. You've got to have program information. You've got to have the posting. So there's a lot of stuff that you've got to do if you're a Minnesota employer leading up towards the end of this year of getting information to employees regarding the upcoming paid family and medical leave law. The state of Missouri, like Alaska and like one other state we'll discuss as kind of a preview, state of Missouri has now brought a new paid sick leave law into effect. It was voted on by residents and approved. So this new paid sick leave law is going to cover private employers with more than $500,000 in gross annual sales volume or business. Similar to a lot of other states, as we discussed earlier, there's going to be 1 hour of paid sick leave accrual for every 30 hours worked. It's going to become effective on May 1st of this year. So in getting ready for this, you want to talk to your payroll provider about having them be able to track your paid sick leave accruals and use by employees. And you just want to make sure that you're aware as a business that this legal requirement is going to be coming into play, that employees will have time off that they can take if they've accrued it under this law. Outside of Alaska and Missouri, the third state that's notable for passing a new paid sick leave law is Nebraska. So if you have under 20 employees in Nebraska, an employee could accrue up to 40 hours per year. If you have 20 or more in Nebraska, up to 56 hours per year. 1 hour of paid sick leave accrual for every 30 hours worked. Again, a very standard formula. This one's going to go into effect a little bit further out. Missouri, as we just discussed, is May 1st. This is October 1st. You've got a little more time to prepare, but sort of the same thoughts are in place of be aware that this legal obligation for employers to accrue and provide this time is coming up. State of New York, another employee-friendly state, relatively speaking. They've done some amendments to their Equal Rights Act. So now the protected classes of sex, sexual orientation, gender identity, pregnancy outcomes, and reproductive health care and autonomy are now covered under their equal rights law. That was effective as of the 1st of this month. That's just, again, those are more items for an employer to be aware of potential areas of protected classes with employees. There's also now paid prenatal leave in the state of New York. Pregnant employees have to be provided with 20 hours of paid prenatal leave each year. Both of these changes effective, again, January 1st. And so they're already in effect, and you need to be aware if you're operating in New York of these requirements. For retail employers in New York, there's a new law that will be effective on March 1st. If you've got 10 or more employees, you've got to adopt a workplace violence prevention policy, and you've got to provide training. Anyone who operates in California is aware of how these go. California has a law regarding a workplace violence prevention plan and training and information provided to employees. New York is following suit with the same kind of requirement now for certain employers. This is a topic we have not talked about much, but COVID-19 sick leave in the state of New York, yes, that's still a thing. However, the law is going to expire on July 31st of this year. It's still in place, probably longer than most states or any other state. They still have a COVID leave law, but it's going to be done as of the end of July of this year. Switching over to the West Coast, Oregon. So they have a paid leave law, and there are some amendments that have occurred. Employees can now use paid leave for a hearing related to foster care, placement, or adoption. That generally falls under the family portion of these leave laws, where you can take care of sicknesses, you can take care of family members, and then some of these laws have also family-related time off that's allowed. This is one of those things. Similar to what we talked about with Minnesota, there are also wage garnishment law changes in Oregon. The new wage garnishment exemption is the amount for Oregon is the greater of 75% of an employee's disposable earnings, or a minimum exemption set by law. So like with Minnesota, if you get a garnishment, you have questions, the laws are changing, reach out to us. This is something that has to be pretty closely looked at. You don't want to make a misstep with a garnishment. Both of these changes went into effect on January, or on the 1st of this month, I should say. The state of Rhode Island has a temporary caregiver leave law. There's been an amendment. So employees can take up to 7 weeks of leave for birth, adoption, foster care placement, and caring for a family member with a serious health condition. That's an increase of 1 week. They used to provide 6 weeks. Now it's 7 as of the 1st of this month. So something to keep in mind if you've got employees in Rhode Island. Following the national trend, the state of Vermont also has a pay transparency law. So now if you're an employer in Vermont and you've got 5 or more employees, you've got to include the wage ranges in your job postings. the range of compensation in Vermont means the minimum and maximum annual salary or hourly wage that the employer expects in good faith to pay for the job at the time the employer created the advertisement. A covered Vermont job opening would include a position open to internal or external candidates, as well as positions which an internal employee could transfer. So that's just something to keep in mind. It's fairly broadly applied if you're doing business in Vermont. It does not require, however, a general description of benefits or other compensation, but it does have to cover the pay and the pay range that somebody could expect. So it's going to become effective on July 1st of this year. So you want to start thinking about that if you operate in Vermont, and how you advertise jobs will now be changed by law. We're talking a lot about today, number one, either new paid sick leave laws or changes to existing paid sick leave laws. Well, Washington State, they don't want to miss out. So they've got changes as well. So now we've got some additional further allowable uses of Washington paid sick leave to include a school or care location closure due to a government emergency declaration. So that could be for things like a fire, a flood, something along those lines, or if there is a disease outbreak, paid sick leave would now cover some of those absences for your employees. There's an updated definition of family member. It now includes household members that and also individuals with a relationship with the employee that creates an expectation of care. So it doesn't have to be a blood relative. It doesn't have to be a person by marriage. It could be somebody where you're just taking care of them to the point where they would expect that care would be provided. That's now a covered person under this change in the law effective the 1st of this month. Also, amendments to the Equal Pay and Opportunities Act. Pay discrimination based on protected class membership is not allowed. That's going to be effective on July 1st of this year. People may ask, well, pay discrimination based on protected class is probably already illegal, or is already illegal under certain federal laws for anti-discrimination, probably other state laws as well. This again kind of goes back to what we talked about before. States that are more employee friendly, even if there are already some laws in place protecting employees on certain topics, they are taking another step and passing more laws or more requirements to make sure that any protections for employees are very locked down. And I think that's what this is. This is a reaction where they just want to make sure they've got a separate standalone law or portion of a law that they can use for enforcement purposes. It's just another, again, arrow in the quiver or tool in the toolbox for an employee to use against an employer if they feel something has been violated. So we've gone through our state updates as we do each year, but I want to touch on also some broader federal issues that people wonder about. We've got a brand new federal administration as of 9 days ago. A lot of sweeping changes are happening with employment law. There are also some bigger trends out there. We're going to start that conversation today just at a kind of a higher, broader level. We're going to hit on a few topics here, but then as I mentioned, please pay attention to our newsletter. Look for upcoming webinars, because we're going to go into some more depth on some of the new changes that will be occurring with employment law or employment law related topics under the new administration. The overall belief is it will be a more employer-friendly set of changes, but the devil is always in the details. So we just want to bring you up to speed on some of the bigger topics that we're thinking about or that were mentioned. One of them, of course, is wage and hour issues. Those are always a huge question from a lot of our clients. So minimum wage, there's not a change expected at federal level. It's not something that was campaigned on in the last presidential election. Instead, it's likely that the new administration is going to rely on income tax credits, changes to the tax code, not wages, but changes to the tax code that would allow more take-home pay for employees. The thing you've got to think about, though, is, again, there's reactions, there's an action and then there's a reaction. So depending on who's in charge at the federal level, states and localities may push against that current administration in different ways. one of the ways that we're going to see a push, or that we've already seen against this current administration, will be, well, if you're not going to raise the federal minimum wage, hey, in this state or this city, we're really going to raise the federal, or we're really going to raise the minimum wage. So anybody who operates, who's listening, who operates in a more employee-friendly state knows already there's an absolute patchwork of laws across the country. Some states have a high minimum wage already, but then some cities within those states may raise it even higher, thinking of maybe Washington State and the city of Seattle as examples. So that's something to be aware of, but the change is likely not going to happen at the federal level. Exempt salary level, there were two changes that were done through rulemaking last year. That one of them did go into effect, and a second one was supposed to go into effect on January, or the first of this month, January 1st, 2025. Both of those ended up being blocked by federal court. And so we are back at the previous salary level at the federal, on the federal side of $35,568 per year for an exempt employee, provided they meet one of the exempt categories at $684 per week. It's not likely, with what we're seeing, that that's going to change under this new administration. Another federal item that we've had a lot of questions on, and there's been some movement over the last 4 years, the independent contractor rule. Worker misclassification, as any of you know who have listened to any of our other webinars, misclassification is a huge risk. It happens when an employer treats a worker as an independent contractor when they are in fact an employee. There's a variety of tests out there for who's an employee, who's an independent contractor at the federal level. There are a number of tests. We're talking here about the United States Department of Labor. The IRS also has a test, but that's one of the things that we're considering to see what's going to happen with some of these independent contractor rules federally. So if you accidentally or intentionally misclassify a worker as an independent contractor when they're an employee and you get caught, the penalties are back pay. There's overtime that has to be paid, back benefits, insurance, fines. The current rule is basically a 2024 test. It looks at the totality of the circumstances, looks at the economic realities. There's no single factor that is controlling. It looks basically at 6 factors, including investments made by the worker, provides control. It looks at some other things along those lines, the overall context of it. So what is being thought now is that 2024 rule might go away. There could be a return through the DOL rulemaking process to a rule that would be more simple for employers to follow and thus more employer friendly. It would instead likely focus on the nature and the degree of the control over the work and the worker's opportunity for profit and loss versus a very detailed 6-factor analysis that might be broader. So that's something to watch with the independent contractor rule. National paid leave. The administration that just came in, it's unlikely they're going to push for this for private sector employees. During the first administration, that was an issue that was out there: paid family leave, paid parental leave. There was a family member of the president from between 2016 and 2020 who said, hey, I'm a mom. I think that this would be a good idea. There was a government paid parental leave law that came into effect in 2020. But again, that's government employees. Private sector, it's not likely that that's going to be a priority of paid family leave or paid parental leave for this current administration. We're going to touch briefly on DEI programs. This is something that's been in the news a lot in the last 9 days. Stay tuned, as I've been saying, to our newsletter email, because it's likely we're going to be doing a separate webinar on this topic at some point in the future, just because it's a hot button issue, it's contentious, it's out there, and there are moves being made in the private sector at the government level, and also with some state governments, for example, that are really trying to get into position on this issue. So we've heard in the news in the last week that a lot of private organizations are rolling back their DEI initiatives. To give you just kind of a brief refresher, diversity means the existence of a variety in the workplace. So that could be age, ethnicity, physical abilities, family status, national origin. Inclusion generally means providing a work environment that welcomes all kinds of backgrounds, provides opportunities for all employees to make contributions. So that's the diversity and inclusion. The issue that comes into play with these programs being challenged is generally the equity piece. A lot of times some of the programs with the equity piece, they would focus on the same outcomes for everybody, meaning there's an engineering of how things are done to get everybody to the same place versus equality, which is different from equity. Equality means equal opportunity versus equal outcomes. So that's where the rules are really being challenged, is in the equity space, is if they're talking about equal outcomes, taking extra steps sort of thing, versus equality, which is equality of opportunity. That's been the law for 60 years. That's where kind of the friction points are coming in. So as I mentioned, a lot of private organizations, businesses, some schools, things like that are rolling back their DEI initiatives. They have fear of lawsuits. There was a U.S. Supreme Court case within the last couple of years regarding school admissions that has a lot of employers concerned about how some of the reasoning in that case could be applied to their workplace. What we're expecting to see, and what's already sort of happening, is that the current administration is going to focus more on equality, again, opportunity, versus equity, which is, again, outcomes. Really, they're going to be focusing specifically on race and sex-based quotas. If you say we have to hire this many people of a certain sex or this many people of a certain racial background, that could bring scrutiny onto an organization that has that type of quota in place. So that's just something to consider, that the big argument is going to be that equal opportunity is the correct interpretation of how to do this under the law, not equal outcomes. But again, we're going to have probably a separate webinar on this at some point in the future coming up, but I just wanted to broadly mention it today to keep things in mind for everybody. Another item, we sort of touched on it when we mentioned minimum wage, but there's an emphasis, or will be an emphasis likely with this administration, regarding reducing worker taxes. That means if their taxes are reduced, workers can take home more of their pay. So in Congress in 2024, both parties proposed laws that would eliminate federal income tax on tips. That was a big issue already coming up as the campaign was going last year. So the TIPS Act came from the D side of the aisle, and they want to eliminate federal income tax on tips. They also want to eliminate the tip credit. Just as a refresher, a tip credit allows an employer to pay a tipped employee lower hourly rate than minimum wage. So this law proposed by the one side would have gotten rid of federal income tax on tips, but would have also eliminated employers' ability through the tip credit to pay a lower minimum wage. The other law that came from the R side of the aisle was a No Tax on Tips Act. That would eliminate federal income tax on tips, but it would not get rid of the tip credit. It would still keep the tip credit, again, allowing employers to pay a lower minimum wage to tipped employees. Despite this law, possibly being looked at through congressional and executive action at the federal level, it's expected that states are going to do everything they can, especially the more employee-friendly states. They're going to do everything they can to raise the minimum wage. That's going to be their approach. They're not going to be worried about lowering taxes. They're going to worry about raising the minimum wage. Another campaign issue that was discussed last year was no taxes on overtime wages. That would cover both federal income tax and payroll taxes. That's another way to keep employee wages higher by reducing their tax burden, but it's unclear where that's going to go. And then the other piece of it, as always, is if you're in a state that has a higher payroll tax level for employees, the federal changes might help, but it wouldn't increase the take-home pay of employees to the extent that they would like. So how can we help you? this is a lot of information today. Again, state level, federal level. Some things have already happened. Some things will be happening. It's a time of very dynamic change. I think we're going to see a very interesting year for employers with employment law, with a lot of these things happening, the federal steps taken, the steps taken by states, either proactively or in reaction to what the feds are doing. So how can we help you? Well, ask us. We're tracking the important employment law changes. We are aware of the federal stuff. We're aware of the state stuff. If you're a client, send us a ticket. I've mentioned this several times. I want to mention it again. And we've also got a link on the side of your screen to sign up for our newsletter. Our weekly newsletter is providing updates. It's getting you information on some of these broader things we're seeing, but it's also talking about specific changes that may be occurring. There could be a new state thing happening, and we provide that type of information within our newsletter. And then if you're talking with us, we can advise you on the best way to handle these new laws. Sometimes there's an issue if there's a new federal regulation that conflicts with, say, a state rule. We can help you navigate that process so that you're going to land on both feet and not get tripped up with this information.